Hey, good morning. My name is Lance French. I'm the Director of Marketing for W&M Environmental, and I'd like to welcome you to our webinar on hazardous waste management in the healthcare industry. Our panel of experts today is W&M's Lori Siegelman. Lori, and we also have Pat Larkin with us. He is the leader of Environmental Law Practice Group with Strasburger and Price. Welcome, guys. Thanks for joining us today.
Good morning.
Good morning.
So before we get started, I wanted to go over a few housekeeping items. If you have any questions, please send them to me through the chat tab on your GoToWebinar window. If we don't get to your questions, I will make sure that they see it and we'll get an answer to you as soon as possible. We are recording this webinar and it will be available to rewatch later this afternoon. Along with the slides that they use, I will send an email with a link when they're made available. So that's enough out of me. So, all right. Well, first I want to introduce our professionals, our experts, if you will. So, Lori, you've been with W&M. How long have you been with W&M now?
I've been with W&M 8 years this year.
And we were joking earlier this morning that says that you win the acronym. You're the acronym winner of W&M because you have a lot of initials behind your name. Can you kind of go over what all those initials mean?
I am an acronym collector. Yes. Industrial hygiene is more the health part of the health and safety. So evaluate chemical exposure, dust, noise, things like that would affect your health from some type of exposure scenario. Certified safety professional is more the physical hazard aspect of it. Fall protection, confined spaces, things like that. CHMM is certified hazmat manager, and that's more the waste side of things, which is really where I started in haz waste and chemical safety.
Okay, excellent. So Pat, you're the leader of the Environmental Practice Law Group. What does that mean?
Sure. We've got a number of environmental law professionals at Strasburger and Price. I help herd the cats and occasionally keep them focused on doing some of the same things. But what it means to be an environmental attorney in our group is to help our clients to identify liabilities, to monetize what the liabilities or potential liabilities will cost, and then try and mitigate it. And that applies in transactions, in enforcement cases, in civil liabilities, in all the main aspects of environmental law. And of course, we work closely with people like Lori and others at W&M as we get down into the hard math and things like that.
How long have you been practicing?
I've been practicing since 1988. I've been with Strasburger and Price since 1999. Before that, I was in-house environmental counsel for American Airlines, and before that, I was an enforcement attorney with EPA Region 6, focusing on RCRA and other hazardous waste enforcement cases.
So to say this is in your wheelhouse, this is definitely in your wheelhouse.
This is one of the things I do a lot of.
Okay, yeah. Excellent. Okay, well, so not being in the medical field, going through this, I just have a question. So there are a lot of types of medical waste. So Lori, will you kind of help explain the different types of medical waste? Biohazard waste, medical waste, and is hazardous waste, is all medical waste hazardous or vice versa? Or did that question even make sense?
Well, no, the terminology of that question really isn't really on the mark. But when you say medical waste, to me that means the medical waste that includes body fluids, sharps, and things like that would be generated in a medical facility or healthcare facility, and also termed red bag waste, and that's managed under a totally different set of rules than the haz waste rules, so to speak. So that would be the medical waste. Then you've got hazardous waste generated in a medical setting or a healthcare setting, which would be in maybe lab waste if you've got a lab in a hospital or a freestanding lab. Then you've got pharmaceutical waste or pharmacy waste, which is could be hazardous waste as well, hazardous pharmaceutical waste, which would be more like your chemo drugs or your other types of pharmaceuticals and drugs that fall into the category or meet the criteria of being a hazardous waste. And then you've got all of the different definitions of hazardous material, hazardous substance, that have different meanings depending on what regulatory agency you're dealing with, whether it's DOT, EPA, OSHA, or whatnot.
So it makes sense why medical facilities need your expertise, because that's a lot to keep up with. Or does it just sound like a lot to me?
Well, one of the interesting complexities of the overlay of hazardous waste laws in the medical context is that all these medical facilities generate lots and lots of medical waste. That's what they primarily generate. But they only generate a little, very small, tiny bit of hazardous waste. And sometimes they can generate that real efficiently or manage that very efficiently and very cost effectively. But under some circumstances we'll talk about, they have to put in this huge additional hazardous waste management regime on top of their medical waste management regime. And that's where the rub is in the medical hazardous waste context.
Okay. All right. Well, let's go to the next slide. So RCRA, why it applies? Who wants to tackle this one?
Well, first, I think we've thrown this term RCRA out here, and maybe some of our listeners won't know exactly what that is. So really quick, I'll explain. RCRA is the acronym that stands for Resource Conservation and Recovery Act. And that's the act really that is all about hazardous waste at the federal level, and how it should be managed, that EPA implemented way back in the 70s. So that sets out rules for generators of hazardous waste, which would be your laboratories, your hospitals, your healthcare facilities. So those obligations then include you have to know what your wastes are before you can figure out how to manage them and what level of rules that you fall under.
And sure, and the point Lori makes here, the most important one is that there are a number of different categories of regulation under the RCRA, under the hazardous waste rules. There's the kind of simplified, the exempt category. There's the small quantity generator by volume, and then the large quantity generator by volume. In each of those, the obligations and paperwork and operational requirements ramp up, significantly based upon how much you generate. And as this slide starts with, we've got 5 bullets here, and the first bullet refers to exempt site hazardous waste. And that's sort of the yellow brick road or the golden ring, whatever the trite comment there is. If you can at all, you want to have an exempt site where you have very limited hazardous waste regulatory obligations. But that depends upon how much hazardous waste you generate. So in order to know that, you need to know and understand each of the potential categories of hazardous waste that you might be generating at your facility. You don't have to do that every single day, but at least once you need to understand all of your waste streams and whether they fall into any of the boxes that are referred to in those last 4 or 5 slides. Back to Lori, if you want to touch on each one of those.
Right, yeah, and in order to figure out if you're exempt or not, or whether you're a small or large quantity generator, there are a lot of different exceptions, exclusions, and exemptions of what waste counts towards your generator status. And it's generated a monthly generation rate, and I see time after time facilities that are using manifests solely as the only way to count how much hazardous waste they've generated. And sometimes it matches up with how much is generated on a monthly basis, but more often than not, it doesn't. And people are confused by that. They just figure, well, I can take how much hazardous waste I sent off site during 2015, for instance, divide it by 12, and that's my monthly rate, when that's not true. Whereas it may match up, but more often than not, it doesn't. So it's every month. But then you have to know the difference between acute and non-acute waste, because that changes how you add things up. And then you have to know what is a listed waste, what's a characteristic waste. So you have to know all of these different rules, and when you count things, when you don't count things, and on and on. It becomes very complex very fast.
But the simplest way of, or a simple scenario might help describe this. A freestanding hospital that perhaps does some complicated pharmaceutical treatment may handle a lot of different types of pharmaceuticals that could be a hazardous waste, but they only dispense them in very, very small amounts, and the amounts that might be generated as a waste are super small. So they usually fall within the weight category as a conditionally exempt or very small quantity generator. It's only when a hospital like that matches up with some other operation that pushes them up over the volume thresholds. And the most typical one we see, of course, is laboratories. They tend to, if there's a pathology lab attached to the hospital, say it's got a large birthing operation, then they tend to generate large volumes of waste, ignitable hazardous waste. And that one's, and ignitable waste by itself is pretty easy and straightforward to manage. It all happens in one location, and you've got professionals that handle that every day, and they know and follow rules. But then sometimes what we see, and maybe I'm jumping ahead to the problem category, is that the people that are managing the pharmaceuticals don't realize that their lab bumped them up into the upper category, and they never take the steps, they never realize that their pharmaceutical waste has to be managed like a hazardous waste. And it's very challenging for hospitals to manage little tiny bits of hazardous waste in a bunch of different locations in the hospital by people that are not typically trained in managing hazardous waste. So that's sort of the confusing, scary scenario, but it's got a very simple solution. That's to understand where it is and what part of your operations bump you over the thresholds, and then find out whether you can pull back the volumes you're generating and pull back under the exempt quantity status.
We're good?
Yes.
Okay, excellent. So it's going to bring us to our first poll question. So those of you that are listening, I'm going to launch a poll, and there we go. So the question is, the EPA divides the healthcare industry among three categories. Which of the three have the most facilities? I'm going to give you guys a few minutes to get your answers in. So Laura, when you first read this question, you were like a little perplexed on what we were trying to go for.
Right. I wasn't sure exactly how this fit into what the relevancy was to this particular topic. And then Pat reminded me that it was in the new proposed rule, which I think he has a lot more information on that than I do.
Okay. Well, good. We'll kind of,
Sure.
That's a good segue here soon. So let me go ahead and close the poll and then share the answers that we have. So we don't get to see it on our screen, but 50% said ambulatory healthcare services and 50% said nursing and residential care facilities. So which is the correct answer?
That would be B.
That is correct. And why is that?
Well, actually, in the proposed rule, that category B is more fully described as ambulatory and other healthcare services. So it's kind of a bucket of categories of locations that EPA expects to occasionally generate pharmaceutical hazardous waste. And so it's the biggest, and it's all the outpatient care facilities, all the surgery centers that don't fall into those other two categories.
Yeah, and it wasn't even close. I mean, it was a huge number, that the number of facilities, but ironically, they all generate equally the same amount of waste. Does that sound correct, or would you say that the hospitals would be generating more, or what would you say?
What's interesting about that is that they might all be generating about the same amount of hazardous waste. It's just that the hospitals are regulated more often than the other ones, because each of them generate by weight a very small amount of pharmaceutical hazardous waste. But it's the hospitals that are paired with laboratories or other operations that in the aggregate push them out of the exempt status. The nursing homes typically don't have labs. The ambulatory facilities don't have labs. So they're just handling that tiny bit of pills that fall on the floor, or a nicotine patch that fell on the floor, or some granules of Coumadin that's been wasted. And also the nursing and residential care facilities, and this is another perhaps webinar topic someday, they tend to handle what's considered a household hazardous waste, because the personal pharmaceuticals of people in nursing and residential care facilities often are their own property and aren't prescribed to them. So it's the same drugs that are prescribed and used at all these other locations, but for another reason they don't fall into a category that adds up to get over the threshold. Maybe a long-winded example of why, the key is to understand what are the buckets that the different wastes fall into and ways in which it adds up and may or may not trigger full regulation.
And Pat, I know that you mentioned some of the types of pharmaceutical hazardous waste, like the nicotine patch and leftover pills from a pill pack. But my experience also is what might be tricky is empty containers and chemotherapy pouches and things like that had the very toxic or the acute hazardous waste. So then with the definition of empty container contained in the RCRA rules, and that the fact that if the container had held a listed waste and you've got a lot of the more acute pharmaceuticals, now you've got this packaging that may be not considered RCRA empty because there's some residue left or it hasn't been triple rinsed. So then you've got this whole management of empty or near empty containers as well to deal with.
Okay, so what is changing? You said the EPA is making some changes. So Pat,
Sure, there's two big categories of conversation to have here. One is that EPA and to a lesser extent the states are looking at all types of generators of waste to see whether they put themselves into the right category. And that has brought in a lot of hospitals and labs and other facilities that were making mistakes and hadn't really calculated what category they were supposed to be in. But they're also doing it in a lot of other operational areas, from oil-filled waste facilities to manufacturing facilities. A lot of people that thought they were exempt left a paper trail behind them that EPA picked up and looked at it and came out and started handing out citations. The other topic that is changing is what we referred to before was the proposed change to the pharmaceutical hazardous waste rule that EPA proposed in 2015. With the change of administration, there's a lot of uncertainty as to whether that's going to go into effect, but it has one huge potential change, and that is for all the hospitals that had been recycling sort of out-of-date pharmaceuticals and allowing that to be managed by a third-party service provider. That proposed rule suggested that they might start treating that pharmaceutical recycled waste that had been shipped off-site as product, that might come back and become part of that hospital's waste. And that, obviously ramps up the potential waste and waste obligations of facilities. Again, that rule is not in effect, but something like that might happen, and it gives another reason why hospitals and all pharmaceutical handlers need to understand exactly what their waste streams are and what their options are for generating. If they still don't hit the threshold for either the characteristic waste or acute waste, they'll still be able to stay exempt if they choose to, but they'll need to understand their operations real well in order to decide if that day comes. But moving back to the first topic of EPA's enforcement regime, they're saving their resources by pulling the waste manifests of all kinds of different generators, especially hospitals and labs, and saying, oh, looks like you're over the threshold, time for some enforcement. Lori, have you seen a fair amount of that?
Yeah, I have. I have seen that in that these smaller labs and smaller healthcare settings that have on-site labs, they generate a fair amount of solvent waste, and they're not really paying that much attention and haven't registered, think they're conditionally exempt, small quantity generator, or really aren't aware of the rules perhaps, and they're not keeping track of their quantity. And so they go about these manifests. They have their manifests that they do every month. But EPA, one day they just get this letter in the mail from EPA that says, hey, we've looked at your manifests from the past 3 years, and there's a couple of them that indicate that you may be a large quantity generator, and you're not registered as such, or you're not registered at all. Here's your triple-digit fine. And then they have to go about getting an attorney, and they don't have the documentation to back up their generator status because they haven't been really tracking it. So I have seen that actually quite a bit lately.
And Lori mentioned smaller facilities. I've seen it at some pretty large facilities too, and EPA assumes that big hospital systems have lots of extra resources pay penalties with, and we all know that there are better places for them to spend their money on, and that's on healthcare.
Okay, so ultimately, this is kind of boiling down to that. Is it when we say surprise visits? Are we saying the EPA surprise visits, or who is doing the surprising?
My recent experience has been it's not so much your traditional knock on the door where the inspector shows up, but rather the letter in the mail that just has hey, in 2016 or 2015 you did this, and here's your fine, basically. And so there's a lot of work that has to go into that. So it's more a surprise letter than a surprise visit is what I've seen.
Well, and the next bullet really tees it up well. How can you prepare? And you can basically do the same thing that EPA has done. You can look at your waste manifests and count up the wastes, first of all, and see whether you've exceeded the threshold numbers and whether you have some exposure. And what we would, of course, recommend is that you do that in the context in Texas of the Texas Audit Privilege Statute, which allows you to notify that you're going to do an audit, disclose it, and then you essentially have penalty immunity and an extended period of time to come into compliance, which is a much better scenario than having a letter showing up saying, pay the penalty, fix it immediately.
So it's kind of like, when you go to your mailbox and you notice that you ran a red light and the city has taken a picture of your license plate and they send you a ticket and they just say, here's the fine. You don't have really an opportunity to argue that. Well, you do. Is it kind of like that? Can you go back and say, prove your case, or is it just, nope, this is what we're going at?
Yeah, absolutely you can. They invite you to either write a check or come and meet with them. But as Lori pointed out early on, after the fact, if you thought that you'd been exempt for all these years, you probably don't have good records that can help you back up and show that you actually were a small quantity, an exempt volume generator.
Okay. So if they get one of those letters, who do they call?
Lori or Pat.
Okay, good.
But more importantly, if there's any risk of getting a letter, if you are a generator of pharmaceutical waste or have a lab, it makes sense to do a real efficient, cost-effective self-audit so that you make sure you'll never get a letter.
Yeah. And I might add too, there might be a lot of people, and a lot of my clients in general think this too, that they have this great haz waste vendor that's picking up their hazardous waste every 2 weeks or every month or whatever frequency. And the vendors are really helpful in filling out the manifest for you, and figuring out what classification your waste is. But I can't stress enough that it's the generator's responsibility to do that. And while it's very helpful for your vendors to help you with that, you need to educate yourself and get the training that you're supposed to have, that you can evaluate and check that service from your vendor to make sure they've done it correctly, because they do make mistakes. In these cases where the vendor is sending your waste off every month, they don't always tell you, hey, you're using these numbers here on your manifest that you're conditionally exempt, but we're shipping off large quantity generator volumes for you. Do you know that's your generator status? They aren't doing that. And so if you're counting on your vendor to alert you to these problems, you might want to rethink that.
Well, and importantly, your vendor, A, doesn't have a duty to tell you whether you're violating the law or not. But B, more importantly, they don't have visibility to your waste generation operations. They're just writing down the information you give them. And if you haven't characterized your waste properly at the outset, you're giving them bad information and they're passing it along.
Yeah, seen it too if you're not tracking the waste and you don't have a good method of figuring out how much waste is in this drum. What's the difference between the actual waste and the container weight if you're shipping out packaging, for instance? If you don't have a good way to track that, then the vendor's going to come in and say, oh, this is a 55-gallon drum of liquid. They're going to put 55 gallons down on your manifest or whatever it is, and maybe that drum's half full.
And a good example of both these problems that Lori's pointed to is I've seen a hospital manifest that triggered an EPA enforcement where it said 50 pounds in 1 month of P, U waste, which are, there's acute waste in there. And there was the the generator told the service provider that there was a possibility of those waste being in there. And then they wrote in the weight of the box. And so the document made it look like there was 50 pounds of acute waste in that month. And there wasn't any of it in there. It's just they wrote down the information that you gave them. So,
Yeah.
you know,
And then all of a sudden, now they're a large quantity generator.
exactly.
Yeah. Okay. So maybe we've already kind of did some examples, but you guys have specific examples you guys want to go over, or do we already kind of touch on
Well,
these?
I might put to you that we've been talking more about the hazardous waste. But if you're looking at, you should really evaluate all of your waste streams, regardless of whether you think they're hazardous or non-hazardous, um, and document that. Now, the EPA or federal rules don't necessarily require you, under the hazardous waste rules, they don't necessarily require you to document your non-hazardous wastes. But in Texas, they do have a little bit different, more stringent rules, and I think, Pat, maybe you can verify or not, that for your non-hazardous waste, the state wants to see that documentation. How did you figure out it was non-hazardous? Did you use analytical data? Did you use safety data sheet data or process knowledge to determine that this waste stream that you're shipping out as non-hazardous waste is in fact non-hazardous? So it's not just a focus on your hazardous waste in that documentation, but rather all of your different waste streams. So then you can have that documentation in your files.
Yeah, and the best documentation to defend your waste stream is one that you did last year, when you pulled together an inventory to all of your potential waste streams and made a conscious decision as to which, bucket, for want of a better word, they belong in. And that's information that you can then show to the government, say, we analyzed this, we had good information at the time, and that's how we made our decision.
Yeah. Oh, and another thing is to consider, too, for the non-hazardous waste, especially in the lab setting where you have a big tendency to maybe to sink or put down the sink certain things, drugs, liquids, formalin solution and things. So you have your non-hazardous waste and your hazardous waste. One more step would be to figure out how you're managing it or how it's managed off-site. Is it going to a landfill? Is it going to an incinerator, a wastewater treatment facility, or are you pouring it down the sink? Or are you throwing it in the regular trash? And then evaluate that. Is that compliant? For instance, you could be putting something down the sink that you don't have a permit to do that. You aren't necessarily required to have a permit, but does your local wastewater treatment facility, your local municipality allow that? And in some cases, you think that they do and they just don't.
And that's
where it's perfectly acceptable somewhere else. It's not in the city that you're in.
And that's a great scenario to think about for everybody that has a lab that is sewering any of their lab pathology waste that comes from ignitable solvents. If they've been if they've been pouring a lot of the waste mixed with water down the sewer, and then the municipality says, no, you have to stop that, all of a sudden your volume of ignitable waste overnight just went from perhaps 0 to several hundred gallons a month. And so that's what we call management of change. If that happens, you're in a whole different waste management regime. And planning ahead for that, if that is a potential risk, is a critical step.
Do you guys see any common mistakes where you go facility to facility that, generally they're going to have an issue with X? You usually have it, or is it different every time you go?
The most common thing I see is things we've already mentioned about the not tracking of the waste, or if they're tracking it on a manifest by manifest basis and not necessarily what did I generate in the way of hazardous waste during this month. So they don't really have a good way to track their generator status, which is most important for the very small or the exempt generators and the small quantity generators, because you want to be able to defend the fact that you're not large quantity, therefore you don't have to do all these extra things. And another thing I see routinely that's non-compliant, not really a waste management issue from a documentation standpoint, but labeling. Labeling is always, I hardly ever go anywhere that the labeling is compliant.
On the waste accumulation?
On the satellite
facilities?
accumulation and in the, mostly in the satellite accumulation in the labs, but a little bit in the storage areas.
One of the scenarios that I see a lot that can lead to big problems is more of a missed opportunity for facilities that do have a large volume of lab wastes that are probably going to be a small quantity generator. They miss the opportunity to document ahead of time that they will never have acute waste that will bump them into large quantity generator status. I think every hospital that has a pharmaceutical operation has the opportunity to go through and calculate what's the maximum amount of the acute waste that they prescribe in any given month or have prescribed, and then usually it's below the 2 pounds because they're in micrograms, this stuff, and so that's the amount that's going into someone's body, not what's being wasted. So they miss the opportunity to prove and document ahead of time that acute wastes can't bump them over the limit. So that's a strategy that they could implement to sort of protect themselves going forward.
Okay, so after the visit, or in a lot of these cases, after the letter. So what are some of the strategies?
Well, the slide that's up there now are really prevention strategies to focus on what to do in an enforcement action. The best scenario is to have had good records and then go to EPA and convince them that you in fact were exempt, and that I think the scenario Lori described before was that the manifest may have had more than 200 pounds in the given month, but it was the time that it was generated was actually during a different month. So being able to reproduce records is a key piece.
Yeah, and some things that you can do after the fact, also like this in this case, is to look at your processes and your waste generating processes and do something like, well, if my hazardous waste is generated in this particular lab, and at full capacity, we have the way the machines run and the way that the waste is generated, this is going to be our maximum daily generation rate. And you can figure that out by just looking at how your processes work and how many machines you have that generate the waste, et cetera, and come up with just how your process generates waste, come up with a monthly generation rate that way, rather than having, how many gallons did I generate, am I pouring into the bucket today with a log. After the fact, you can do it before the fact, just looking at your processes.
Have you ever been in a case where they go to the EPA and try to, defend, and then they've actually gotten in worse trouble?
No, I've never
opened up a new can of worms and said,
not any of my clients.
Okay, well, that's
good. But there's definitely the possibility. Usually, the risky scenario there is pushing too long and too hard and missing out on the opportunity to settle. You have to evaluate the case, on its merits. Most of the time, these are document cases, and when you're busted, you're busted. If they've got the documents, you will sort it out. You just need to demonstrate that you fixed the problem, that you were in good faith compliance at the time, and that you're going to fix the problem going forward. That's really the main menu for after the fact corrections.
And what are the fines generally? I mean, give me a range. You said 3 digits, but that could be.
I know on my end of it, it's the starting point. I'm only aware kind of third hand of it that's been triple digit fines that are started with, but Pat would be more able to answer.
We're not talking $350 either.
No.
We're talking 6 or 7 figures.
Yeah.
Because these are most commonly federal cases, they're working from the RCRA penalty policy, and the RCRA per day per violation maximum penalty is $37,000 plus per day, and you can get 100 different violations in one mistake based on whether documentation was right, whether the site labeling was correct, whether the manifest was right, whether you characterized waste at the beginning. So I think this is most relevant in the context of deciding when do you put your resources in. Do you hope nothing will ever go wrong and just keep plodding along, or do you take a risk on a 6 or 7 figure penalty, or do you put a few tens of thousands of dollars together and do a good audit that will serve you as correcting your problems forever going forward?
That's great.
So I have a quick question for you, Pat. So these EPA, the data mining that they're doing, reviewing manifests and then sending these letters and going for enforcement, if you're an agreement state like Texas is, then what is the probability or possibility that TCEQ will then come along after the fact and maybe do some fines or inspections based on the EPA? And would it be a good idea for these facilities then to do an audit after they've got their EPA letter to protect them from TCEQ enforcement?
That's a terrific point. The EPA case is only looking at what is only penalizing what they found based upon what's on their computer screen. Unless they follow up with an inspection, they're not going to see whether you had labeling correct, whether your satellite accumulation areas were in violation also. If your house is not in order on your waste generation calculations, it's a good bet that there are other potential violations out there. I wouldn't say that the EPA enforcement case makes it more likely that the TCQ is going to target you for a follow-up inspection, but I think it makes it very likely that you have other things that would be found if the TCQ did come. I haven't seen that level of coordination between the agencies.
Okay.
I would note, the slide that's up really are management practices on the front end, things you can and should do to help make sure that your house is in order and that you will prevent mistakes and enforcement actions going forward.
And so what are some of the hangups? I mean, so these are some good strategies. So what are you seeing that, they would look at it and go, those are great in theory, but these are real world scenarios. It's really difficult to do that. Are you seeing anything out there?
Well, supply chain is one of the most difficult things in two areas. Out on the clinician's floor, the nurses and assistants are delivering meds that were prescribed by doctors, and sometimes those meds get selected and prescribed before the hazardous waste managers know what's going to be coming through the hospital. And so that can change a lot. Managing that supply chain is important. To a lesser degree, changes in the lab chemicals that are being used can change your profile as well.
You want anything to add?
Just things that are harder to do or take longer to do would be the training aspect of it, to know to do these things and kind of be able to review your program with the knowledge that you need to make good decisions and do it properly. The training aspect of it is a little bit difficult.
I would imagine, because you have, I would say in a hospital, you probably have a lot of people making those decisions. Is this hazardous? Is this non-hazardous? Is this, right. I don't know, so I'm just going to put it in the red bag. I mean, do you guys see that, or those some?
Yeah, you have it split up between different people, and these people, hazardous waste management isn't their job. They didn't go to school for this, and that's not their primary responsibility. And so they don't really have a knowledge base to draw from.
Okay, good. Well, that brings us to some questions. If you have any questions, feel free to throw them into the questions tab. I do have a couple questions right now if you guys have a second to answer them. So if I'm recycling my solvent waste, then isn't that exempt?
Solvent waste, if you're recycling it, there are some exclusions and exemptions when you're counting waste. To determine what your generator status is that you only have to count your solvent waste once. So the first time you generate it, and you can do it a couple of different ways, I guess, and Pat, pipe in if you have a different opinion or something you can add. But if you generate a solvent waste, say in the lab, and you're accumulating in a 5-gallon tote or bucket, and then you take it down the hallway and put it in a distiller and recycle it, then you count that as hazardous waste that's been recycled once. That's been generated once. And then you get, that's 4 or 5 gallons, and you get another 4.5 gallons out, and you use that again, and then you recycle it again. You only count that initial gallonage one time as hazardous waste.
And you can also diminish that number even further if the recycling happens before it goes to a satellite accumulation area. If it's being recycled as part of the operational process, that process, the materials that come out and get reused are not a waste. And so it's usually a solvent and water, and it's being distilled. So the water and solids that come out, that's the only part that's the generated waste. But if you go, as Lori said, down the hall and you have recycling facilities in different parts of the hospital, you risk having that entire waste stream, being a waste rather than a product that's being reused.
Right.
The entire process can be diminished if the waste stream that comes out of that distillation process, you can find a place that will reuse it in a similar process. The federal EPA and the state agency have adopted rules that allow, if you have a verified recycler that is reusing your particular, in this case, solvent for the same or similar purpose, you had never generated any waste. You are just having it being reused.
And I think that's the same concept they use with all the parts washer machines, that the ones that are still using solvent-based cleaner in it, and you have the service that comes and services those parts washers. They take that waste off just on a bill of lading, and it never counts towards your generator status because of that exemption there, because they're reusing it as an ingredient to make more of that solvent. It's the same concept there.
Okay. Our next question is, what if I'm sending containers of pharmaceutical waste? They weigh on the manifest, including containers. How do I figure out my generation status? Do I need to repeat that question? Because I might have.
No, I think I understand, because this is something Pat touched on, is that you don't need to include the weight of the packaging. You only need to include the weight of the actual hazardous waste toward your generator status. So I think there's a way to do that on the manifest, right?
Yeah, I think it's either box 13 or 14. You can make a note saying the weight listed, it includes packaging. You need to be careful about that and make sure that it also asserts that you have previously analyzed that the amount included will not put you over a threshold. So I've seen clients that have looked at what their pharmaceutical generation over the course of several years looked like, determined that they will never ever hit thresholds, and they made a note of that on every one of their manifests.
So you were talking about going to a simple audit to come in, and so a lot of these things, a lot of these areas, they're looking just like, what's going to cost me money? But what you're talking about too can actually, a lot of times, maybe even save some facilities money, or is that rare?
No. If you're managing your hazardous waste, it's like any other type of business process. If you analyze it up front and figure out how you're managing it and managing it properly, and kind of look at different ways to reduce and quantify it properly, it's going to give you opportunities to save money. Yes.
Have you ever had that happen?
Well, absolutely. I've helped clients determine that, in fact, they did qualify for an exempt status if they made some changes to the solvent they were using and changed some other processes.
Yeah.
And they basically stopped having to document all their operations and manifest everything. That's fairly unusual, but it's that level. You need to understand your process pretty well in order to decide what your options are.
Right.
Okay.
And if you decide that, I have way too much solvent waste just going out the door, that's not exempt or excluded. Now I'm a small quantity generator, but hey, if I get this distiller, I can change that. So by doing that, then you get the distiller, you reduce the virgin solvent that you're having to purchase, and so that not only saves you in the haz waste management arena, but also in how much you have to purchase as well.
Okay. Good. Okay, we have two more questions. Did the EPA recently change a rule on hazardous pharmaceutical waste?
Right, and I touched on that before. That was the 2015 rule, and I'd urge people to go and look at that and find that in the Federal Register, because it sets out what might be the future of pharmaceutical hazardous waste. It proposes to have an entire separate management system, sort of like what we now have for paint waste and fluorescent bulbs, sort of like U-waste. And it's like that in the sense that it's a whole nother set of record keeping that you would have to do. And so I'm not offering that as good news, but it's a possible scenario. And it's another reason to go through and see if you can become a very small quantity generator. Because if you can get out of the system that way, you don't have to make that decision of whether you stay on the current waste management system or go to that new pharmaceutical waste system.
Okay. Last question. So what happens if you don't fix or address these issues?
Well, you might get one of those surprise letters, and then not have anything in your file to dispute that information with, and now you have to go spend a lot of money and a lot of effort in attorneys and consultants and things to help you.
Yeah, the thing that I find is typically the most distressing to business operators, including hospitals and other medical professionals, is that they have to change their business operations and their patient care in a really short period of time. They might have to adapt to a whole new system of managing waste, and then they've got all these great medical professionals sitting together in a room trying to figure out what bag to put something in, and it takes up all their valuable time when if they, planned on the front end, none of that would have had to happen. Or if they did an audit and they found the problem, they would have maybe a year to have those conversations and put things together in an efficient way. So what happens on the back end is you get a whole bunch of urgency and a whole bunch of costs that you can't avoid. And those are all very avoidable.
So that brings us to the end of the webinar. Thank you, guys. It was a great, informative webinar. I appreciate your time. And here's Lori and Pat's contact information. And if you need to get a hold of them or have a question, their emails are up there. Or you can also just call us at W&M Environmental, and we can absolutely get you in contact with either one of those. So thank you both for joining us today. Anything else to add? And we're good. Okay, so
Be safe out there.
be safe, and okay, well, great. Thank you, guys. Have a great weekend. We're close, so talk to you soon.
But you can't call me.